Morning, everyone. Welcome to the District of Columbia Court of Appeals. We have two cases on this morning's regular calendar. We will first hear Jimmy Johnson versus United States, number 25 CF 198. We'll hear first from counsel for Mr. Johnson.
May it please the court. Good morning. My name is Keith Laughlin. I am representing appellant Jimmy Johnson in this case. With the court's permission, I would like to reserve 2 minutes for a rebuttal. And with the court's indulgence, I would like to begin with the legal sufficiency issues in this case, as those issues inform the analysis of both the severance and improper argument issues raised in our briefs. The old adage that a picture is worth 1,000 words suggests that a dispositive meaning or essence of an event can be conveyed by the recorded images of that event. However, as recent events in the news inform us, often images require words and additional vantage points to provide essential context to fully understand what an image conveys. This is one of those circumstances. Mr. Johnson's conviction is based on the theory that the video depicting the assault of Mr. Nicholas Lucas on June 11, 2023 depicts the entire story of the events that occurred that evening. Yet, Mr. Lucas's own account of those events, from his initial interviews with police, through his grand jury testimony, and crucially his testimony at trial, places those events in a fundamentally different context, a context that negates Mr. Johnson's intent to commit any kind of assault that evening. The account that Mr. Lucas gave of those events places Mr. Johnson in a fundamentally different posture than the assailants that evening. Specifically, Mr. Lucas consistently testified and stated that Mr. Johnson was intervening in his defense throughout the assault, that Mr. Patterson and the two unnamed assailants were consistently advised by Mr. Johnson to stop doing what they were doing. Mr. Johnson further suffered manifest prejudice from being tried jointly with Mr. Patterson due to this fundamentally different nature of his interactions with these assailants that evening, and was further prejudiced by the taint of Detective Coven's testimony regarding his investigation of Mr. Patterson's misconduct, a taint that on this record could not have been cured by the court's remedial measures. Turning first to the legal sufficiency arguments, the government's theory hinges on the question of what does the video alone tell us of Mr. Johnson's intent? Our position is that the video from a static position with events significantly obscured cannot tell the entire story of these events, and specifically cannot stand when rebutted by Mr. Lucas's contemporaneous and consistent accounts of the assault.
Counsel, I don't know that anyone was suggesting that the video told the entire story. I mean, the video depicts only part, there are things that were happening off the screen of the video. So for sure, the video is only a part of what was going on. But I think that the government's theory was that there is one thing in the video, which is that you can see your client shoving the victim, and that if that's what the video depicts, or if that's what a reasonable fact finder could see the video as depicting, then that fills out the rest of the story or provides a context for the rest of the story that on balance permits a reasonable juror to find guilt. And so is it your view that no reasonable fact finder can look at the video and determine that your client shoved Mr. Lucas before Mr. Lucas fell face first to the ground?
When juxtaposed with Mr. Lucas's own account of the events, no.
Okay, can I ask you, and why would a fact finder have to accredit any aspect of Mr. Lucas's account of the event as it relates to the degree of involvement or lack of involvement of your client? I mean, the jury is free to believe witnesses in whole or in part, and generally the credibility of those things is left to the jury. So are you saying that a reasonable fact finder couldn't say this video looks like your client is shoving the complaining witness to the ground, and although the complaining witness is coming into court and testifying that the overall, it doesn't really directly address that question. In part, I'm not sure the complaining witness knows who shoved him. It was from behind and the like, but definitely provides an exculpatory version in testimony. But why was a fact finder required to accept that as somehow undermining what a fact finder might have viewed from the video itself?
Under these circumstances, I think that the government's case presents a binary. You either believe one or you don't believe the other. And given that Mr. Lucas's own account of the events was consistent in that he believed that Mr. Johnson did not touch him at any point. Even he testified to that both at grand jury and at trial. And notwithstanding what the video appeared to show, Mr. Lucas provided a vantage point of events that.
But isn't it a big problem for you that your witness doesn't really remember the event at all of the pushing and falling to the ground and getting his head hit? In other words, there's not a conflict of testimony. There's a inability of your witness to be able to say anything about an event that he can't remember. Do I have that wrong? That's what the government says.
That is certainly the government's position. However, the video, that is one construction of the video. However, even if you take into account apparent deficits in Mr. Lucas's ability to perceive those events, he was consistent in his testimony, notwithstanding having seen that video multiple times prior to his testimony and during his testimony. So even if he could not have perceived the events contemporaneously, he had ample opportunities to view the government's evidence, and notwithstanding those opportunities, still consistently testified, I don't believe that Jimmy Johnson touched me.
I mean, did somebody at trial show the video to Mr. Lucas and say, how do you interpret what the government is arguing is a shove from behind by your client, which the video would suggest Mr. Lucas would not have been able to determine who was doing that. But did somebody say, let's look at the video, let's freeze it here. How are you interpreting these events? Is that something so did he directly testify? No, that's definitely not, that's not Mr. Johnson. That must have been Mr. Patterson, or one of the masked individuals, or someone at least who was not Mr. Johnson. Was it presented to Mr. Lucas that way at trial?
That was not part of the government's presentation, and the defense's line of questioning on cross was simply to elicit, no, Jimmy Johnson didn't touch me. Every time I heard Mr. Johnson that evening, he was counseling the other assailants to cease the assault, and it's specifically referencing the portions of the 1 October 2024 transcript during his testimony. I don't, based on my notes and recollection of the transcript, believe that was the line of questioning of either the government on direct or during cross-examination.
In response to Judge Sedgman's question, you were saying that it was one interpretation of the video that Mr. Lucas might not have been in a position to see who shoved him. And then he hits his head and he seems like he's kind of dazed, and so he might have concerns about lack of recollection. But it's more, I think, than just an interpretation of the video. My belief is that, and you can correct me if you have a different belief, but I thought that Mr. Lucas actually testified at trial. I don't remember being being hit in the head from behind. I don't remember falling down. Am I misrecollecting that, or?
No, I believe that's the correct interpretation. There was a gap in memory from when he was struck in the head and went down to when he eventually ended up in his car and was able to drive himself to seek medical attention.
So I guess in one way, the sufficiency question could be viewed this way. I'm interested in your response to it. The issue would be, why couldn't a reasonable fact finder take that evidence and look at the video and say, it looks like Mr. Johnson shoved Mr. Lucas from behind. Mr. Lucas at trial here obviously doesn't believe that, but he wasn't in a position to see it from the video who shoved him, and he's testifying at trial. He doesn't remember, falling to the ground, and so we're not going to really give his trial testimony a lot of weight in undermining the conclusions we draw from the video. What would be wrong with what would be unreasonable about a fact finder taking the evidence as a whole in that way?
It would be inconsistent with the government's theory of intent, as given Mr. Lucas's overall testimony, specifically that Mr. Lucas testified that he consistently heard Mr. Johnson counseling the other assailants to stop, which is consistent with Mr. Johnson acting in defense of others that evening. So that interpretation, in light of the posited memory deficit, would be inconsistent with Mr. Lucas's overall recollection of the overall course of events.
I get that line of thought. I guess I have two questions about it, and one of them is although I think you've been accurate and very precise in what you're saying, that Mr. Lucas was consistent in his testimony and in his statement to the police that he didn't believe that he was touched by Mr. Johnson. But the government argues that the statements to the police were not entirely consistent among themselves or with the testimony at trial, and in particular that Mr. Lucas at one point told the police that his belief was that your client might have orchestrated the whole thing because of some prior unspecified prior incident. And so could a reasonable fact finder trying to put all these pieces together take that as tending to undermine the credibility of the exculpatory testimony about your client's general activities during the incident?
We would take issue with that characterization of the record. Specifically, there's nothing in Mr. Lucas's testimony that he had had any negative prior interactions with Mr. Johnson, and specifically referencing the 1 October 2024 transcript at pages 27 through 38. That colloquy went to his relationship or prior relationships with both, and ability to identify both Mr. Patterson and Mr. Johnson, and he was specifically asked whether or not he had had any negative prior interactions with Mr. Johnson, and he
that's his trial testimony. What the United States is relying on is evidence about statements to the police, and they're citing the October 1st transcript in the 85 to 88 range as indicating that Mr. Lucas told the police at one point, and maybe not at the hospital, but in a later conversation, that he believed that your client may have or might have or something like that orchestrated the situation or this incident based on, quote, a previous situation, whatever you thought that meant. Are you recalling that testimony?
I do not specifically recall that testimony. I'm just specifically referencing Mr. Lucas's characterization of the prior relationships at trial, what was before the jury in terms of the sufficiency of their findings on that question.
I know you're running out of time,
Yeah.
And you wanted to save some time for rebuttal. Do you want to quickly address? You mentioned your severance point. So, do you want to quickly address that before we?
Yes, I'll just briefly sort of overview of the joinder and severance issues because they relate to the insufficiency claims. The manifest prejudice that Mr. Johnson suffered from the joint trial was in that the evidence that established that his role not only was de minimis compared to Mr. Patterson and the other assailants, but was fundamentally different in that he was acting in Mr. Lucas's defense. And he was the prejudice he suffered from Detective Coven's improper testimony is just an extension of the pain from the joint trial in that Detective Coven's testimony went to Mr. Patterson's course of misconduct. And on this record, it's impossible to determine whether or not the taint of being conflated with that assault could have been cured by the court's remedial measures. Without further questions, I see that my time has expired.
We will give you your 2 minutes in rebuttal.
Appreciate it. Thank you.
Here now for counsel for the United States.
May it please the court, Jordan Hummel on behalf of the United States. Mr. Johnson's assault with significant bodily injury conviction should be affirmed because it was supported by not only sufficient evidence, but ample evidence, including of his intent, principally the video that shows him shoving the victim to the ground forcefully, causing the victim to cut his forehead and bleed profusely onto the sidewalk. Additionally, there was no error, certainly not plain error, where the trial court did not sua sponte sever these trials. First, Mr. Johnson never requested to sever the trial from his co-defendant.
Did he really? Wasn't that in a motion to sever filed August 31, 2024?
Yes, that motion was to sever specific counts that related to a firearm that was recovered on Mr. Johnson at the time of his arrest, but that motion never requested to sever the trial from his co-defendant. So that was actually never before the court, and the court never rules on a motion to sever.
Well,
The reason I suppose that you don't argue on the severance issue, you say this is plain error review. And the whole question is whether or not he did or did not preserve it for appeal. Is that it? I mean, I was surprised the government relies so much on saying it was plain error review rather than saying, well, hey, even this is not a severance case under the normal rules of severance. And therefore, there shouldn't have been severance in any circumstances. Or is it because the trial court severance decision is discretionary and the trial court never really ruled on it?
So we raised both arguments, but starting with the plain error review, because this is something that the trial court never rules on. It's not brought up in the pretrial motion. It's not really brought up at trial. There's some scant references to a hypothetical motion that defense might have made had the court made a different evidentiary ruling. But of course, that doesn't happen.
What I'm asking you is, what do we do if we say that the government is wrong, that he did do enough to preserve it for appeal? Do we then say, well, yes, that's true, he did preserve it, but the trial court never ruled on it, and therefore it was the job of the defendant to ask the trial court to rule on it if he wanted to preserve it?
Yes, the defendant would have had to seek a ruling here. And we think this also was not a close case for whether the cases should have been severed, where the evidence against Mr. Johnson is not de minimis. It's quite strong and even stronger than his co-defendant as to the assault with significant bodily injury. There's also independent evidence of his guilt through the video.
You say it's quite strong, and you rely logically enough on the video, which I feel like I watched a lot of times. And would you agree that a reasonable fact finder could be uncertain about exactly who was doing the shoving in the video, or do you think it's the only reasonable way a fact finder could look at that video would be to say, obviously that must be Mr. Johnson who's doing the shove that immediately precedes Mr. Lucas's falling to the ground.
Yes, we think that is the reasonable view of the video where.
The only reasonable view.
Well, yes, because we have the victim testify that Mr. Johnson is wearing these gray New Balance sneakers, and on the video you see the victim wearing his white tank top. You see the individual that's wearing the gray New Balance sneakers behind him take the victim by the back of the head and forcefully shove him.
What?
Well,
I couldn't really see the like what the relationship was between the hand/arm that's doing the shoving and the feet of people, and then someone walks out, and it does seem pretty quickly after that Mr. Johnson, identified on primarily on the shoes, walks out, but it didn't seem to me that a reasonable fact finder could only think that that arm, that the hand and arm that did the shoving related to the body that then walks out with the shoes that seem to have been connected with Mr. Johnson. But you think that's the only reasonable way of looking at the video, is that hand and arm, because at the time of the shoving, I don't think you can see the shoes, if I'm recalling correctly. So it's kind of an arm comes out into view, and then the body and the shoes come out.
I believe the shoe may be visible when the arm is there, but if not, it happens almost instantaneously. And it doesn't seem reasonable that there would be enough space between the victim and the individual wearing the shoes that somebody else could have gotten between them to shove. It just doesn't seem like that
You
would
at
be
least see
reasonable.
the bottom part of a shirt or jacket, right? And that it moves when the shove is happening, and then that appears to be connected to the person wearing those shoes.
Yes.
So there's at least some sort of kinetic evidence there. And I'll nitpick you on my original point in a second, but also, what do we make? You bring it up and you focus on it, that Mr. Johnson otherwise is just standing there while the victim is bleeding on the ground, and at the end when he's robbed further appears to just be walking away. And is that really evidence that he wasn't trying to help out, or just evidence that he only did for some period of time?
I think that's evidence. Well, of course, the only evidence that we need to focus on for the sufficiency is for the assault. So we believe that that happens. That's contained within the video that shows the shove. But the additional evidence of him standing around, him not aiding the victim, goes to his intent to show that this was not an accident or a mistake, that he did intend to shove the victim to the ground. Otherwise, if it was an accident, you could reasonably expect that he would have tried to help him up off the ground and not walked away or stepped over him. So that speaks more to Mr. Johnson's intent in showing that this was what he wanted out of his actions of shoving the victim down.
All right, and if I can close the loop for you, I promised I would nitpick you one more time on mine. It's not a huge point to me, and I don't know that it ultimately changes anything, but on that motion, it was to sever the counts of the indictment, but it ended with, in the quote, "and to order separate trials." You don't think that we can reasonably interpret that, ignoring the issue that defense counsel did not go and seek the ruling on that point? But you don't think it'd be fair to interpret that in any way as requesting severance of the trials?
No, because I believe that that refers to separate trials for those counts. So for the 3 counts of the firearm related charges. So I believe that that's what's referred to there. There's no discussion about severing the trial from the co-defendant. So I think that would need to be something that was fleshed out for this court to say that that's what was meant by that request for relief. And as to the striking of the detective's testimony, there was certainly no abuse of discretion. The court correctly identified this court's precedent in Walker and did exactly as Walker dictated. After the appellant objected to the mistrial, the court carefully considered the available remedies and chose to impose a relatively severe sanction of striking the detective's entire testimony. This was entirely proper and not an abuse of the court's discretion. If there are no further questions, we ask that the judgment be affirmed.
Thank you, counsel. Mr. Loughlin?
Just to address the overarching concern with the record from Mr. Johnson's perspective, the Mr. Lucas's testimony establishes that there's no true common scheme or plan or logical connection between Mr. Patterson and the two unnamed assailants and Mr. Johnson's actions that evening. Mr. Johnson consistently was placed in the role of acting on Mr. Lucas's behalf, and in his defense, the obscured video of the shove, that whatever precipitated him going to the ground, it's impossible to discern who the actual source of that injury what was. And that is consistent with this court's precedents, that where testimony or physical evidence can disprove a factual finding, evidence will be held to be legally insufficient to sustain a conviction. And the crucial vantage point that Mr. Lucas provided regarding his own assault provides circumstances here that disprove the government's theory and negates the inferences that Mr. Johnson intended to assault.
Let me understand this. Are you saying that no reasonable jury could conclude that your client was the one who pushed the victim?
Our position is.
I thought your theory was that, yes, the sneakers indicate that it was the defendant that was doing the pushing, but you have this testimony from your witness that he never actually touched your witness. And therefore, the whole thing came down to a question of whether or not, assuming that your client did the pushing, was there adequate proof of intent? But now I keep hearing you saying, well, maybe it wasn't him at all.
We certainly do not concede that Mr. Johnson pushed Mr. Lucas that evening. And consistent with Mr. Lucas's testimony, it's impossible to discern what Mr. Johnson was doing relative to the other assailants at that point, other than it being consistent with Mr. Lucas's account that Mr. Johnson was acting on his behalf and in his defense. The source of injury is one question in terms of whether or not this record supports Mr. Johnson actually pushing Mr. Lucas. And there's a separate question of whether or not in the overall ambit of the events, whether or not whatever actions Mr. Johnson was taking, physically interceding, if he did touch Mr. Lucas, whether or not it was done with the requisite intent to commit an assault, or whether it was, perhaps to get one of the other assailants to refrain or physically intercede from one of the other assailants committing a more grievous assault against.
So in other words, a reasonable jury could conclude that Johnson was there with his sneakers, that somebody at that point pushed the victim to the ground, but there's inadequate showing that the person who did the pushing was the same person as the person who had the shoes. In other words, Johnson.
Correct. And that's
okay. So that's the evidentiary issue right there, according to you.
Yes, just given the static nature of the video and the obscured portions of the events that were occurring.
Okay.
And with
course, the jury was there and watched the whole scene and concluded that your client was guilty.
Certainly,
They concluded that the guy with the shoes, namely your client, was the pusher.
uh,
And you're
that,
saying nobody could think that, so was from what was shown there.
that it on this record and given the government's proof, our position is that evidence was insufficient to establish
Okay.
Mr. Johnson's guilt.
Thank you.
And for these reasons and others that appear in the record, we would ask that this court vacate Mr. Johnson's conviction for assault under count 5 of the indictment. Thank you.
Thank you, counsel. We appreciate your briefs and your arguments, and the case is now submitted. We'll hear the second case on this morning's calendar, Griselda Martinez-MOZ versus United States, number 24 CF 828.
Morning. May it please the court. Abraham Fernando Carpi on behalf of the appellant, Griselda Martinez-MOZ. May it please the court, Your Honors. Your Honors, this is a case that concerns a very unique question of law. If you want to undertake the plain error review of the matter, as well as the arguments that were preserved below, as to whether a transgender defendant can assert the defense of actual impossibility, not legal
Can you
impossibility, but
clarify
actual
for me on
impossibility.
your actual impossibility? I saw at least kind of two bases in there. One, an idea that I struggle with a lot, that
Yes, sir.
that a transgender person, I guess it really was more of a sexual orientation argument. It wasn't that you were saying that a transgender person has to prefer a transgender woman has to prefer men. It was that your client in particular prefers men. And then the other aspect of it I saw, which I didn't see anywhere in the actual record in front of the trial court, was evidence about hormone therapy that you said would have made it impossible to accomplish penetration. Which is
Right.
the
So-
angle you're relying on?
Yes, sir. We can go back on the record. You will recall that defense counsel asserted to the court, to Judge O'Keefe, that they had identified some medical records and they had consulted with a couple of experts that were at one point identified that would testify that based on the fact that Martinez-MOZ was undertaking hormone therapy, that her testosterone levels were low and therefore erection would be not as feasible or possible. Government counsel interviewed those experts. They withdrew their motions to exclude because they had filed motions to exclude those experts on legal grounds. But the defense was proffered. In other words, the actual defense.
Can I interrupt for a second? Was any of what you're just saying now actually introduced into evidence in front of the?
No, unfortunately, it was not, Your
So
Honor.
how would we be in a position to assess the viability of that defense if it had been submitted to the jury, if it wasn't, because the evidence in support of it wasn't presented to the jury?
Very important question, and the answer is very difficult. Very difficult to assess how that defense could have been presented. But there was some evidence that my client was transgender presented by the government's witnesses. Both the mother and the grandmother.
That is true, but I don't think you're suggesting that the mere fact of being a transgender woman in and of itself establishes a defense to the charges here.
No,
By
that's
theory.
not, that would not be a cognizable defense just by virtue of the fact that somebody is of some gender identity. No, that would not be a defense. That's why I couch my argument in terms of an actual impossibility defense that was prevented by the court. And if I may, Your Honor, the District of Columbia is unique in the sense that you can request the court to issue an instruction on your defense. In this case, the defense was twofold.
So was there a request for an instruction on actual impossibility to the trial court?
No,
Okay.
and there could not be. Because remember, the defense in this case was, I didn't do this, and I could not have done this. At least that's where the defense team was going with the defense of Martinez-MOZ. If you see the trial record from the opening statement all the way through the evidence that was presented, the defense was going, I didn't do this, the child is lying, and I could not have done this because I'm transgender and I'm going through hormonal therapy. And then the next step was,
Where you get me, where I start getting confused, I guess, is you're saying that was the defense. And at one point, maybe a little more precisely, you were saying that was where the defense was headed at one point. But in terms of the defense that was actually presented to the fact finder,
correct.
there wasn't a defense presented to the fact finder, was there, of impossibility on any
No.
theory, either kind of, I mean, at the extreme, it could be anatomical impossibility, it could be hormone-related impossibility, it might be less impossibility and more something rooted in sexual preference, but that's no evidence in support of that theory was presented to the,
No specific, correct, you are correct. No specific
no
evidence.
instruction to the jury.
And no instruction, correct, but there couldn't be because the court ruled that the events in Maryland that were ongoing, the government argued that the events in Maryland, in the Maryland case, supposedly provided context to the DC alleged crimes. And we'll get to that in a minute because we also believe that that is a structural error. Once the court ruled on that motion, that same day, the court ruled, and specifically ruled, that only a portion of the Maryland crime would only be admitted, specifically the portion of penetration. There was no context to that alleged crime. There were two incidents in Maryland, one in 2017, one in 2019, one in a couch and one in a bed. But the court ruled.
How does that relate?
Yes, and I'll get to that point, yes. The court ruled that only the actual penetration, not the contours of the penetration or the modus operandi or the preliminary events to the penetration would be admitted. So the court held that back in its ruling, saying, okay, well, I'm going to allow this for context, but I'm not going to allow the full event to be disclosed to the jury. The same day, defense counsel noted to the court, by the way, we need these experts to testify in the case. So that's where the defense was going. But when the government interviewed the defense experts, they then filed a motion to reconsider that ruling of Judge O'Keefe. And in that
relating to
motion,
the Maryland, relating to the admissibility of the Maryland incidents?
right. So the government then at that point withdrew their objection to the experts, but they requested Judge O'Keefe to reconsider the ruling on the context of the Maryland cases, because obviously if Martinez-MOZ presented evidence of an impossible erection because of the treatment, then the child's testimony as to the erection, the penetration, and the preliminary events leading to the penetration would be relevant. And then Judge O'Keefe said, that's correct, I will hold on to this. And so the defense consulted with Ms. Martinez-MOZ, and they elected not to present the expert testimony because of that ruling.
And that's might well have been a perfectly reasonable strategic judgment, but it ends up leaving the trial record as, not including any evidence about this possible defense. So
Correct.
I consider it as a freestanding claim that defense should have been submitted to a fact finder. You said it's very difficult to see how we could address it. I was more concerned that it might be impossible. So I'm not sure how that, I guess I could see this as a theory of prejudice
Right.
arising out of the actual legal claim, which would be a challenge to the kind of contingent ruling of the trial court that if the defense puts on this actual defense, this defense of actual impossibility through witnesses, then there'll be a broader array of other crimes evidence that would be admissible.
Exactly.
And so that could have been a legal challenge that could have been raised in this court and is that your claim that the trial, because I didn't really see in your brief the argument
Right. So
that contingent ruling was error.
well, not that the contingent ruling was error. It's that it explains the prejudice to Martinez-MOZ. In other words, Martinez-MOZ.
If it's not error, then that it had, this ruling gave your client a strategic choice to make, that ruling. And your client made one choice, and that may well have been a reasonable choice. But unless that ruling of the trial court that then posed that strategic choice to your client was error, then I'm not sure that it was contrary to your client's interest would be a basis for relief.
Understood. Well, let me then shift now to the Johnson-Tolliver evidence, which is I guess in this context her best argument to obtain reversal of the case. The court was very specific in its ruling. The court said that it was going to allow the evidence of the Maryland case only for context. However, context has to be understood in terms of the mimic exceptions to 544B, which are modus operandi, intent, and obviously the signature of the crime, right? Well, when you look at
Why do you say that?
The-
I thought that our cases, like in cases such as Johnson and Tolliver, suggested that there are kind of the Drew line of cases and the particular exceptions for other crimes evidence in the full sense of that phrase. There's one set of principles, and then there is
correct.
evidence that comes in that is about a separate crime, but isn't treated as other crimes evidence for that purpose, and instead is subject to a different line of authority about coming in, not for any of those exceptions, but coming in as completing the story under cases like Johnson and Tolliver.
Then what-
So why do you say you have to understand
Well, because
one is limited by the other?
Because what is the context? So if the other crime that happens out of state is used for context, there has to be a connection in terms of context. That the first crime in the District of Columbia involved oral sex. It involved, according to the testimony of my client, disrobing the child, touching the child in the top part of her body, then touching the child at her bottom part of her body, and then penetrating the child.
Why does that have to be the context as opposed to this is an incident that happened and it triggered the disclosure?
Because the only evidence that was allowed in the second incident is just that the child went to bed and then she felt penetrated. There's nothing else. There's no
But that-
context surrounding that except for that testimony of the child.
But doesn't that go to potentially bolstering the credibility of the child and saying something else happened and it triggered this all back after I saw the press-on nail in my room, and that's why I now, years later, made the claim instead of.
Right, but bolstering credibility would not be the reason, Your Honor. That would be essentially disposition slash credibility bolstering for the witness, which is not permitted by Johnson or Drew or any of the cases. What is permitted is only the context so that the other crime is explained. But in this case, you don't have.
I thought the theory of admissibility here is not that the other crime is explained. I thought the theory of admissibility was there is, your client is being prosecuted for offenses that took place some years ago.
Yes, sir.
And there was not an immediate report by the child of that conduct. And if, unless the child's testimony is, here's why that happened. I didn't report it right away. Then years later, I was abused again, and that is what led me to report it. And the theory of admissibility is that allowing testimony about the later uncharged abuse to explain the delay in reporting, the lack of a prompt report and the delay in reporting is completing the story of the charged offense and why it came to be reported when it did, as it might relate to a fact finder's assessment of the credibility of the child's claim of prior abuse. And
that would be okay, but the court only permitted, the court did not allow the contour of the attack, the whole attack.
I thought that was in an effort to protect your client from, unnecessary revelation of all of the details of the later incident. So the idea would be unhelpful to your client to get out the details of exactly how that later abuse
That's
occurred.
what was asserted. Yeah, that's correct. That's what was asserted. But so what is the context then of the child just simply saying that she went into a bedroom and she felt penetrated? What context is that?
And that's what led her to report prior abuse. What more context is needed to explain that sequence of events?
Well, if you see, again, if we go back to the first event and the second event and the third event, when I hear the word context and when I read the case law, the context has to be also encompassing of the other two events. And I understand the court has perhaps a disagreement with me as to.
Let me ask you this.
Yes, sir.
What do you want? Do you want a trial in which you can raise this defense that you didn't raise before? Or are you asking for a trial in which this other crimes evidence is not introduced at all?
I would prefer both, Your Honor, if I may, if I could have my election of remedies. I can only deal with the transcript and what my predecessors did below a trial as best as I can. That's why I'm raising the issue of the
This is
actual.
all kind of strange. I don't recall that this stuff was all really briefed very well, but maybe it's there.
And it's raised to the extent that it was not preserved in law. And Judge McLeese asked the proper question, which is, was this preserved? The actual impossibility defense, was it preserved? I don't think it was raised in that context. There was some evidence that my client was transgender, was transitioning. There was evidence that the defense counsel aimed to present evidence of hormonal deficiency that was ultimately not presented. But at bottom, what we have is now a person who's transgender who wanted to defend on those two fronts. One is, no, I didn't do this, and two, I couldn't do this because I'm transgender and I'm taking
But
hormonal
the
therapy.
counsel say to the judge, look, you're limiting the amount of information that you're allowing me to put in on the other crimes evidence for this particular offense. And that prevents me from raising a defense that I want to raise. And therefore, would you please do X, Y, or Z?
No, Your Honor, they didn't.
Was that asked for?
No, Your Honor, prior trial counsel did not do that specifically. And that is one of the biggest problems in this case where, again, I'm dealing with a transcript conducted by my predecessors below a trial where they didn't do a number of things. I would disagree that a lot of those things were
They made
tactical
a
decisions.
tactical decision to.
I don't think so.
not
I don't think there were tactical
take that
decisions made.
defense, probably because it wouldn't have worked.
And I think in this case, based on the circumstances that we have, I would ask the court to take a look at the transcript, see how the defense moved on. And for those reasons, I would ask the court to reverse the judgment. Thank you.
Counsel will give you a minute or two in rebuttal. We hear now from the United States.
Good morning, Your Honors. May it please the court. Mark Hobel for the United States. Let me begin with the actual impossibility evidentiary claim. The defense has conceded that this claim was unpreserved and is subject only to plain error review. There's no plain error. Again, as the defense has acknowledged, there was no evidence to support this claim, no instruction to support this claim. The claim itself is unclear and not supported by any authority cited by the defense. So there was certainly no plain error associated with the initial claim related to actual impossibility. As to the admissibility of the Johnson evidence, the defense conflated Johnson and Drew evidence. The mimic exceptions do not apply to Johnson evidence. Johnson evidence is direct evidence of the crime charged and provides context. And here, this court recognized in the Brown case that a valid theory of Johnson evidence is other crimes that triggered the disclosure of earlier charged sexual abuse by a child victim. That's exactly what we had happen here. There were two Maryland incidents, one of which the couch incident was kept out. The other incident, the June 2019 incident, occurred in NC's room. That the evidence of that incident was limited by the judge to prevent undue prejudice to the defense. But it was the government had a reasonable need to present it to explain to the jury why NC disclosed the earlier abuse from several years earlier. It was because she was triggered by the resumption of that abuse by the defendant. Again, under the Brown case, that it was not an abuse of discretion for the judge to keep that in, and it adequately balanced the 403 equities and reasonably did so by limiting the amount of information that the government could present. So the trial court did not abuse its discretion in admitting that Johnson evidence and did not plainly err in failing to consider the actual possibility defense that the defense ultimately chose not to present to the jury. Unless there are any further questions from the bench, we would ask that the trial court's judgment be affirmed.
How about the variance?
The variance. Variance was also not preserved. No claim was presented, variance or amendment claim was presented in the trial court, so that claim is subject to plain error. In terms of plain, there was certainly no plain error based on the Carter precedent, which we cited in our brief, which says that it's not an essential element of the crime, whether it's oral or vaginal sex. And additionally, any prejudice was certainly mitigated by the specific unanimity instruction and the verdict form, which clearly indicated that the jury determined the defendant's guilt in the second incident based on vaginal contact with the child victim.
You mean it's not plain error because they didn't ask for it before the trial?
That's correct.
And therefore, the rule is triggered that says if you don't ask for it before the trial, you're under plain error review.
That's correct. And I hasten to add that the standard of review is not whether under error or plain error. Carter and the specific unanimity instruction means there was certainly no constructive amendment, and the defense never raised a prejudicial variance claim. But there was no timely objection during trial when additional action could have been taken to mitigate any prejudice. And so plain error applies to any variance claim. But again, there wasn't any error, plain or otherwise. There was a clear, specific instruction that said the jury.
Well, let me ask you this. If there was in fact a variance and you didn't ask for it before trial, are you precluded? Are you still under plain error review? Or is that a structural error, which they argue, which means that the trial is invalid because there was no proper grand jury indictment?
Well,
that's the part I don't understand.
Right. It's certainly not a structural error. I mean,
it's not structural error if there is a variance in fact.
Well, that's
per se reversal.
It goes to a particular count. It's not a structural error. Typically has to do with the structure of the entire trial. All we're talking about here is count two. We're not talking about count one.
No, I know count two. Yeah.
Right. If there is a constructive amendment, i.e. a fatal variance, that it is reversible. That is correct. However, even structural errors are subject to plain error review if they are not properly preserved.
Okay.
Okay. I'm happy to address any further questions. Otherwise, we would ask this court to affirm. Thank you.
Counsel. Mr. Carpio,
Yes,
we'll give you a minute. We'll give you 2 minutes.
Thank you very much, Ron. Just McLeese, I just wanted to address your last question before I go on to Judge Steedman's follow-up questions with government counsel. We talked about the context, right? Well, the contour of the testimony of the child on the incidents in Maryland was very narrow. And if you look at the transcript on pages 29 and 30 and 116 and 117 of the March 14th and March 18th, the child essentially is testifying as to what happened. The judge narrowed it to went to bed, felt the penis inside. These events happened in July the 17th and the 19th. Then 10 days later, so not in the same night. The child doesn't testify. That's that night when she was attacked allegedly by my client. She went to her mom and said, "Listen, this is all coming back now. This is what happened to me in Washington D.C. at Riggs Road." She's using the same modus operandi. No, that doesn't happen that way. She's allegedly attacked. Mom comes in, finds my client in bed with her. My client was visiting. Then the child moves out, doesn't say a word. So there's no context to the other crimes. Then 10 days later, the child testifies that she finds the acrylic nail of my client. And then at that point, it all comes back. So there's no immediacy to the offense on the 17th or on the 19th. It's later in July of 2019.
Yeah, so I mean, I get that line of thinking. That seems different from how detailed the testimony was about that incident, the sexual incident, the second sexual incident in Maryland. So this line of thinking seems to be, it may be okay to put in evidence of a later assault if it explains the failure to report earlier ones, but that's not okay unless that later assault triggers immediate reporting. So if there's a delay that's, further delay that's of some days, that somehow categorically precludes the idea that that later assault could be used as explaining the delayed reporting. Is that seems like the line of thinking here. I get that line of thinking. I'm just wondering what support why you think that should be the law, or if there's
Well,
law that suggests
well,
that's
this case is unique. It's not the same as Brown or the other cases. So this case, the facts of this case are completely different. When the court ruled that the court was going to allow the July 19th event for context, and then limited the context to that the child went to bed and then she felt a penis, knowing that the child subsequently testified, "Oh, and I just got off my
Here's
bed."
where I'm getting, sorry to interrupt, but I'm getting confused about, I get your point about delay. I'm not sure I, think it should carry the day for you, but I understand that line of thinking. But then when you start wrapping back around and saying, expressing a concern that there should have been more details introduced about the exact way in which the second Maryland assault occurred, I don't see how that, it seems unhelpful to your client. It doesn't seem to address the delay point. So I don't see how that connects to your delay point
I only
in a
made-
way that's helpful to you. So that's what I'm missing.
I'm sorry, I only made reference to that in the context of the court reserving the other facts of the second assault in its ruling, and how that prejudiced my client when my client then the same day presented the potential defense of hormonal therapy. And then when
I understand that set of
that's the-
procedural
that's
points.
the
That's a separate,
context.
okay, I understand that too.
Yeah.
Okay.
So I am referring now to the context, which in my view, based on the case law, should be at least logically connected with a timeline. In this case, we're talking about, and I haven't finished, the child in July of 2019 then finds a nail, tells them, and then she testifies, and this came out of context, but it's not until August 21, so a month later, when she goes to the sexual exam, and then she reveals, oh, by the way, the person that did this is a friend of the family who's transgender. So we're not talking about a 10-day or 20-day delay. It's a 2-month delay from the event in Maryland all the way to August the 21st when the child testifies. This is when I tell the same exam nurse that this woman did this to me. So that would be contextual, proper under Johnson, but because he has, it would be a timeline if it happened the same day. But this happened 2 months later. The revelation of the context is 2 months later. So for those reasons, Your Honor, I think the admission of this evidence was improper. Now, going to Judge Steeman's question about the variance, you're correct. My position is that in this case, there was a fatal variance in the case, and for those reasons as well, the case should be overturned. Unless you have any questions, sir.
Thank you, counsel. The case is submitted. We thank both counsel for their briefs and their arguments, and we will now stand adjourned.
All right.